Recently, I had the opportunity to read several trusts written by other people. And I'll tell you that there's a lot of commonality from one trust document to the next. Attorneys tend to copy that which has worked successfully for others before. And I think they should do that. But when you get down to the specific provisions, usually the gifting provisions that the attorneys have drafted for their clients, sometimes they're drafted by paralegals as well. That's where things tend to get a little hairy, so to speak. Here's the problem. Client Smith comes in and he's got 3 pages of things that he wants the attorney to do in his trust or his will. They're in no particular order. Sometimes they appear to conflict with one another. Sometimes the client wants to give gifts that are an invitation to a problem. For example, client might have 4 children and 8 grandchildren, and he just wants his house to be used for whoever needs a house. Well, that's an invitation to a legal fight, and only the attorneys are going to win. So who owns the house under that gift? I don't know. Who's going to pay the utility bills? Client probably didn't think of that. Who's going to have the authority to borrow some money and put a new roof on? Who's going to have the financial responsibility to pay the deductible on the insurance? And on and on and on. So since I've been doing this for a long time, I don't want to tell you how many years, more than 20, I wanted to tell you some thoughts and ideas I have that might help some of you draft gifting provisions. First, you need to make sure that you are clear in your mind that you understand all of the gifting provisions that your client has written down. And then you might consider one by one dictating those provisions into an audible recording that you or your assistants can refer to in the future. I like to do this dictation right in front of the clients so that they can correct me if I misunderstood, or if perhaps they noticed that, boy, that was not sounding so intelligent once I heard it out loud. And that happens. It happens to you and me, probably. Sometimes what we think doesn't sound so smart when we say it out loud. Once you've dictated all of that, and your assistant or perhaps your software has reduced all of that to text, then let's break it down even further. I would suggest that you take your text document and that you combine certain areas of the gifting together. Every gift that is for the benefit of child number 1 be gleaned from the document and put together in a single area and separate from the gifts to child number 2 and the gifts to grandchild number 1 and so forth. Then as I began typing my gifts, I would separate them into very short paragraphs, each paragraph dealing with a single gift to a single person, or perhaps a series of persons. So for example, my paragraph might say, I leave my house at 1804 North Main Street to my son Bill. But if Bill does not then survive me, to his children in equal shares. But if Bill leaves no living children, then this gift shall go to First Church on West Main Street, and so forth. When I have completed the gift of the house, I would then open a new paragraph. Then I would go back and read the first paragraph aloud to myself and make sure that I don't have run-on sentences and that there is a logical flow to the gift. Then begin to work on the second paragraph. To my daughter Jane, I leave the sum of $100,000, provided that if Jane is then incapacitated, this gift shall be put into a special needs trust for her care for the rest of her life. New sentence, if there is anything remaining in this trust upon the end of Jane's life, then it will be distributed outright to Jane's then surviving children, provided that if any of them are incapacitated, their share will be gifted into a special needs trust for their life, and so forth. And then I would start a new paragraph. I leave my primary automobile to my oldest grandson, but if I have no grandsons surviving at that time, then to St. Jude's Children's Hospital, etc. Break down each gift into small bite-sized pieces that can easily be understood by the reader, knowing that it may be years or even decades. This provision is put into place by someone who has never met you, never met your client, and has never seen any of these items, that being a judge, of course. So avoid run-on sentences, avoid long paragraphs, search for clarity, brevity, and concise language. All of this will make your client's goals much more likely to be achieved. If you need help with this, please feel free to engage our office, Oklahoma Estate Attorneys. I'm Terrell Monks. I'm the senior attorney there. Our phone number is 405-733-8686. Thanks, guys.